Please be seated. We'll have hear argument in 2505, in re Eagleridge Operating.
May it please the court, Mr. Hollenbeck will present argument for the relator. The relator has reserved 5 minutes for rebuttal.
Good morning, Mr. Chief Justice, and may it please the court. This case presents the question of where to draw the intersection between several legal threads of precedent in this court and between Chapter 33's statutory language requiring the submission of a responsible third party where it is in any way responsible for the harm alleged, as well as I mentioned before, this court's precedent prescribing the liability of premises owners and contractors hired to install and perform maintenance work on equipment on the premises, and what happens after the premises are sold. Here, the trial court and a majority of the Court of Appeals held that a jury in this case may not consider whether a contract operator who was paid to install and maintain equipment on an oil and gas lease was in any way responsible for the harm that resulted when that equipment failed. Instead, those courts held that a jury is prohibited from considering this conduct as a matter of law because that contract operator also owned a minority working interest in the lease, which it sold before this accident occurred. This holding is incorrect for several reasons. It conflicts with the direct and clear statutory language of Chapter 33, and it conflicts with this court's precedent recognizing the separate duties of a contractor that exist even after it leaves the property. Those holdings are in Occidental versus Jenkins and Strakos versus Gehring. So the two reasons that we think this court should reverse and grant mandamus relief are that Aruba owed a duty in this case, and two, a subsidiary question under Chapter 33. To submit the conduct of a responsible third party, a defendant does not need to show proof of the existence of a duty because that requirement is not found in the language of the statute. Here, Aruba Petroleum, despite being a minority working interest owner in this lease, was separately hired and paid to install and maintain not only this well, the Donald 2H well on this property, but the piping and compressor equipment that was with it. The testimony in the record is quite clear that it was separately paid as the contract operator. Again, under most joint operating agreements, there is one contract operator, a railroad commission contract operator, I think is the full term. And that is what Aruba's position was in this case. It also had a minority working interest in the property. So it shared in the expenses from the development of minerals on this property, but it was indisputably separately paid to do the work that involved installing the equipment that ultimately failed in this case. So we believe this case is very different from the case relied on principally by our friends on the other side, Occidental versus Jenkins. Of course, this court is familiar with Occidental. It held that Occidental, who is a fee simple, if you will, owner of the premises, installed equipment on the premises, built it out of its own expense, and then sold all the equipment, all the land, lock, stock, and barrel to Equistar. 8 years later, an Equistar employee was injured by that equipment while working on it. And this court held that Occidental owed no duty after it sold everything to Equistar for any accident that happened 8 years later because it was a premises owner. I think that's quite similar to if I install a fence on my property at my own expense and I sell the property down the road, many years later, someone's injured on the fence, they can't sue me as the previous owner for some defect on the property. And that's quite sensible, and that makes sense. But this court also acknowledged a different duty, a different responsibility that would exist where you're dealing with an independent contractor who comes onto the property. And for example, this court, Justice Devine, writing for the court, wrote that when the property's dangerous condition is caused or created by another, not the property owner, an independent claim against the other may lie in negligence. And that claim, unlike the premises liability claim against the owner, does not necessarily end with the property's sale. And the reason for this is simple. A contractor's duties are tied not only to its control of the premises, but to the quality of its workmanship. And this latter duty can be judged under ordinary negligence principles even after the contractor no longer controls the property. Here, Aruba installed this piping, was responsible for maintaining it. It was its interest, which is believed to be a minority working interest in this property, was transferred to USG Properties in May of 2017. This accident occurred 3 months later when Mr. Lovren was out there inspecting the compressor on this well, which had shut off for some reason.
Your first argument is that the statute doesn't require a legal duty to add a responsible third party. How do you respond to the part of the statute that talks about you cannot allow submission to the jury a question regarding the conduct of any person without sufficient evidence to support the submission? That seems a little bit different than other cases where there's a potential defense or the person is, there is a duty, but they're potentially judgment proof or for some other reason unable to pay the judgment, and there's a decision, we're not going to sue this person because
we can't reach them, we can't serve
right,
them.
There'd be a legal duty.
There's a bar.
But there'd be a legal duty and they're responsible, but we don't want to sue them.
Or
As
they
opposed
can't.
to a case where you're saying, a person doesn't have to have a legal duty to be responsible.
Well, what we rely on is the language of the statute itself. And in the statute, it says that what is a responsible third party? And so it defines responsible third party as any person who is alleged to have caused or contributed to causing in any way the harm for which recovery of damages is sought. And then it lists some examples, whether by negligent act or omission, by any defective or unreasonably dangerous product, or any combination of these things. And so, as this court has held, I think in Galbraith, the touchstone is responsibility, not liability. And when you were looking at this, I'd sort of rely on the statutory canon of jusdem generis, although this is sort of the reverse of that. Jusdem generis, it talks about if you start with a series of rather specific examples and then you have a catch-all at the end, you understand that this broad catch-all at the end is really limited by the examples that precede it. Here you have the reverse of that. Here you say any person who is alleged to have caused or contributed to causing in any way the harm for which recovery of damages is sought. So you start with this broad language, and then you have some examples that follow it, which under jusdem generis can't then go back and narrow the in any way. And then it says by any combination of these things. So the language itself is very, very broad. I think the legislature certainly could have drafted the provision, this is 33011 sub 6, they certainly could have drafted it to be limited and more narrow, but it didn't. In fact, the only exception that it included is that responsible third parties do not include sellers who are eligible for indemnity under 82002. The words of the statute do not say any person who may have had a duty but just can't be sued now, or may have owed a duty but there's a bar to it. It says any person who is alleged to have caused or contributed to cause in any way the harm. And so you start with this very broad language, and this court has interpreted it very broadly. In Neighbors versus Romero, I believe the court said, the directive is clear. Fact finders should consider each person's role for causing in any way the harm for which damages are sought. And I think this is echoed when you look at the bases for filing a motion to strike an RTP. And that's what was filed in this case. It was a motion to strike Aruba as an RTP. And that is actually very narrow. And this is 33004 sub L. And it says that after adequate time for discovery, a party may move to strike the designation of a responsible third party on the ground that there is no evidence that the responsible third party is responsible for any portion of the claimant's alleged injury or damage. Now, we know when it uses the word responsible that it's not talking about liable. Because again, the whole underpinning of responsible third parties is they can't be found liable based on a jury finding of percentage of responsibility against them in this suit. Any finding by a jury of responsibility against an RTP is not collateral estoppel, it's not res judicata on that RTP's liability. So we
But
know that
to go back to Justice Bland's question, how could you submit somebody that didn't owe a duty? How would there be sufficient evidence to support that submission in the statute's words if there's no duty?
because responsibility in the statute means causation. Responsibility does not mean a legal duty. Because here you have, what is the basis for striking an RTP? That there's no evidence that it is responsible. That's the ground, that there's no evidence that it was responsible. We know responsible can't mean liable. So what does it mean? It must mean causation. Causation.
So you don't have to have damages, you just have to have causation?
Well, I think it's responsible in any way for the harm that resulted in the case. So yes, causation for the damages. Yes, you have to damage. Obviously, if the plaintiff doesn't have any damages, then there's no case against anybody.
How do you know if there's been a breach if you don't know what the duty is?
Well, it's a breach of a standard of care.
Right, but if there's not one, then how do you decide whether they're responsible?
Well, if there's no breach of a standard of care that caused the harm, then the jury would put 0 on the blank.
How is the jury going to do that if they don't know what the standard of care, if there isn't an applicable standard of care?
Well, the standard of care would be, for example, negligence in maintaining this, failing to act as a reasonable and prudent contract operator on the premises to maintain the property, in this case, to properly bury it, to wrap it against corrosion.
Right, and I understand
Yeah.
you have an argument in this case that they actually did owe a duty, so we don't
Right.
even need to get to this Chapter 33 issue because they should be treated as an independent contractor,
Yes.
or failing that this was something that they knew about as a premises, if they were a premises owner, that this is something they knew about and should have disclosed. And for those reasons, they do owe a duty to this plaintiff. But,
You've said it better than I could, so.
well, just summarizing what's in your brief, but your other position seems to be that none of that matters because Chapter 33, you get a submission regardless of any of that. And so
Yes,
I'm just trying to
that's-
understand how a
that's the
jury is
subsidiary
going to,
question.
I'm just trying to understand how a jury is going to make that determination if just assuming for the sake of argument you were not to prevail on those other issues and you're left with your Chapter 33 argument and the jury is trying to figure out what it means for somebody to be responsible and what it means for there to be sufficient evidence of that if there's not an applicable standard of care.
Right, well, and I'm not saying there isn't a standard of care. I'm just saying there isn't a duty toward a particular person. Doesn't stop the submission of a responsible third party. Again, this is all framed in Chapter 33, which is talking about how you submit these things to a jury, right? The jury isn't going to decide who owes a duty and therefore who goes on the charge as a party. Again, parties have to have duties, because parties arise under common law. Responsible third parties is this creature entirely created by statute, and so we're limited to what's in the statute. We don't have this common law backdrop of, okay, to be submitted as a party, as a defendant, or a plaintiff in maybe a counterclaim or something like that, you have to have a duty.
But doesn't
to be
the
found
statute
liable.
contemplate that the responsible third party will be submitted to the
Yes.
jury to
If it-
evaluate its conduct?
Unless there is no
So
evidence.
isn't the idea of responsibility somewhat constrained by the notion that the responsible third party has to have had some sort of duty to the plaintiff?
I don't think so, because the statute doesn't require that. The statute talks about responsibility in terms of causation, because responsibility under the statute can't mean liability, because we can't hold
But can someone be a legal cause of damages without having a duty?
without having a duty to do something for
Correct.
anybody.
Right.
Sure, they could be acting negligently, even though they don't have a duty to
Well, they have a duty of ordinary
to
care.
exercise ordinary
If-
care towards somebody. But this is just talking about if there is a breach of a standard of care that makes them responsible for the harm in any way. So I don't think so, because again, the statute could have said duty, that could have been added by the legislature. But again, we believe that the The real thrust of our argument is that Aruba owed a duty in this case. They were clearly the contract operator, and they were hired and paid to do the things that, in fact, the plaintiffs allege they didn't do in this case. As the dissent points out, dissenting Justice Whitehill, I believe, said, the evidence showed that they were paid to do these things, they didn't do these things. There's expert evidence in the record showing the things that they didn't do and how it caused the accident. And in Justice Whitehill's words, the plaintiffs don't argue otherwise. The only ground alleged in the motion to strike was that there is no duty owed by Aruba because of Occidental. There was not a ground alleged in the motion to strike that there's not evidence of a breach of any duty.
Any other questions? Thank you, Mr. Hollenbeck. We'll hear from the real parties.
May it please the court, Ms. Levy will present argument for the real parties in interest.
Good morning. May it please the court. I guess we agree on one thing. There's two issues here. One is, was there a duty? And the second is, does there need to be a duty? I'm going to start with answering the first question, and primarily because that was the question that the trial court addressed, and that was the question that the Court of Appeals addressed. None of these Chapter 33 arguments were raised below. And I understand in the context of mandamus, we don't have a waiver rule per se. It's more of a predicate act, and did you present this argument to the trial court? But I think the practice that they're engaging in is problematic, and especially when you're looking at basically a summary judgment-like standard, to be raising these new arguments for the first time in the Supreme Court kind of highlights the tension with having this particular issue being decided on mandamus review. And so I'm going to turn to the existence of a duty. And I think starting out there, we've got to clarify what duty are we talking about. And because there's two, right? There's a premises liability duty, and that as a landowner or a possessor of land, you have the premises duty with respect to defect to make safe or warn. And that duty always, whether you own the land, whether you don't own the land, that duty is always commensurate with your control, right? Because if you don't have control of the land, or at least the right to control the land, you can't inspect, you can't make safe, you can't warn anybody. You don't have you're not able to discharge any duty with respect to the land.
Unless you fail to disclose a known dangerous condition, right? Then the premises duty can continue if you fail to disclose a known dangerous condition.
Right, it continues until the new owner discovers it, or should discover it, right, under 353. So in this case, we can look at their expert report, and which is what they primarily rely on for their evidence of a duty, and the expert in his report is saying, USG and USG, who's the property owner, and Aruba didn't disclose. They knew about this issue and they didn't disclose. So once USG knows, rather, there's no longer any duty on behalf of Aruba as a former property owner, right? Because now the new, in this case, it's not a new property owner because they were co-owners, but now the person who's the owner, they know, right? And so then they have the duty, they have the right to inspect, control, make safe.
Does the expert report say that they knew that at some time before the accident?
Yes.
Okay, and
Right.
when was that?
I don't know that the expert specifies it as to either party. He generally suggests, anytime he mentions what Aruba should have done, USG's always right there, right? It's always Aruba and USG should have done X, Y, Z. It's never just Aruba. And so.
But that's different from saying USG actually knew.
Well, I mean, this is what should have been disclosed, Eagleridge is claiming, should have been disclosed when they took over as operator, right? Which was before the accident occurred, right? They're saying, when we took over, you didn't disclose this. You knew and you didn't disclose, right? And the accident occurs after that.
Right.
So.
But you're saying that they did disclose, that the expert report shows they did disclose?
Well, the expert report, I don't think the expert says they disclosed. The expert report says USG knew about the dangers on the premises, right? And your duty to disclose is, backing up, your duty is to disclose a concealed defect, right? That the new owner can't discover on its own. And so sort of there's a couple of problems with their 353 argument backing up, because it's not only that they didn't disclose, but it's also, this isn't a concealed defect in the sense that, I understand their briefing makes it seem like this pipe is buried underground and nobody can see it. And I think, that's just not so. And we put, the pictures in our brief because I think it's something that's easier sort of understood by just looking at the picture, right? You have a pipe, coming from a compressor, and it goes down and it's kind of partially buried, and then it comes up on the other side, and you've got some sandbags there and it's kind of stuck underground. So you can't see necessarily what's at the bottom, but from the perspective of an oil and gas operator, you can see a couple of things. One is you can see what kind of pipe it is, because you can see whether it's coated or not coated. And that's important because this is all in a tank battery, and a tank battery is, I think of it like the streets of Houston, right? It's designed to flood. If it rains, water's gonna pile up in there. If there's a leak, if something's coming out, it's all going to be sitting in there. So
When you're talking about the degree of concealment, and one side says it was concealed and the other side wasn't that concealed, why wouldn't that be something that could be taken care of once the responsible third party is added with the scintilla of evidence that they concealed something?
Right.
And then you have the whole presentation of the case to determine whether there's evidence, more evidence than the scintilla to support it. And then you have a jury ultimately determine concealment.
But I don't think
we wouldn't determine concealment at the stage of determining whether the party could be added at all, as long as there was a scintilla of evidence to support adding the party, and then you would go through summary judgment and a trial to determine whether or not they were truly, in fact, responsible.
Right. Well, this is summary judgment, right? So if there's supposed to be a scintilla of evidence presented here, right, that's their obligation. And their evidence is their expert report, right? And sort of these conclusory statements in their expert report about what was concealed, what wasn't. I don't know that would be considered a scintilla of evidence. I would say it's no evidence. The expert saying they didn't disclose, they did disclose, with no evidence in the record to support that statement. That's no evidence, right? If on a summary judgment. So again, it's just stepping back globally, it's their burden to come forward with evidence, right? Just putting your expert report in, that doesn't, I think, do it. If I were doing that as a plaintiff in the summary judgment, I wouldn't expect a great result. And so it's no different here, right? It's a no evidence standard. And I want to briefly, with the court's permission, turn to the Chapter 33 issue, because I don't want to not discuss that. And I think my argument there is real simple. If the court wants to read the language the way they read the language, that same language is in 33, I think, 03A, right? That in any way it's cause or contributing. And that applies to everyone, right? So if we're going to read that language that way, that means settling parties don't have to have a duty. That means defendants, I guess, don't have to have a duty. That's absurd, right? Who would read that language in 33A and say, oh, we can submit defendants without a duty? And I think this goes to your question, Justice Bland. We know that's not true because we can look down at subpart B, and it very specifically says we can't, no person, that includes responsible third parties, may be submitted without evidence as to their responsibility, right? And so I think that applies equally. That's how all the lower courts have interpreted it with respect to plaintiff, if you have a contributory negligence claim, the plaintiff has to have a duty to engage or not engage in some sort of conduct. Same thing with the settling person. Just because someone settled, they don't go on the charge, right? You have to establish, that there was a claim or a cause of action. And
there's usually a separate submission of that claim or cause of action against that party before they're considered in the Chapter 33 apportionment question, right?
Right. I mean, it's, because again, the apportionment is, as to each cause of action asserted, the trier of fact, will apportion responsibility, right? So there's going to be a finding. I mean, I don't know how you have,
But say, even if you're not, even if it's a settling party, for example,
Right.
and so you don't have a claim anymore against them if you're
Right.
the plaintiff because you've settled
Right,
with
right.
them, wouldn't their negligence still be submitted as a predicate to the Chapter 33 question so that the jury would know whether they were
Right.
responsible in
Right.
order to then
Right.
decide the percentage?
I don't know the problem, the second problem with this language in terms of the definition of percentage of responsibility and responsible third party is it's been in the statute since tort reform was born in 1987. That percentage of responsibility definition was created in 1987 as a way to apportion fault. And it is very broad language. And it's broad language because we're apportioning responsibility amongst different torts, right? And so, we may have a products liability cause of action. So we're not going to say proximate cause because the causation standard there is different. And so, and in
Or you
terms of
could
duty.
have fraud or
Right,
some
you
sort
could
of
have,
intentional
there's a
fraud.
whole DTPA now, so you can have any different number of causes of action. And so that's why the language is broad. And if the legislature were going to kind of craft out a different standard for responsible third parties, I don't know why they would do it with language that's been there since 1987, and all of a sudden now it means something different as to responsible third parties. That seems a strange way of doing things, especially when you're talking about something that is completely foreign to tort law. And the problems of figuring out, it goes to your question, about how do we submit this? How do we determine this? It's like, how are we to determine what responsibility means absent, duty, concept of duty that's been there since tort law, we're talking like Paul's graph, right? What standard are we going to apply? And that seems like a very problematic and unworkable standard for courts to sort of determine, okay, and I understand there are rejoinders, well, it's just causation. But okay, no proximate cause now? Any kind of cause? It doesn't say proximate cause in there either,
Well,
right?
could there be a difference just based on the stage of the proceedings? That we're not going to allow submission to the jury of a question regarding the conduct of a responsible third party. Conduct having, to include some aspect of a duty, I think, unless there's evidence to support the submission. But could it mean something different at the time you're determining whether or not to add the third party as a responsible third party? And then we're just looking at a more general,
Right.
or not? Are those standards the same?
So I would say the difference comes at the designation stage, right? That's a pleading standard. So unless they put facts in their pleading, that just foreclose duty, then that's not an issue that's going to be decided then. But once we get to the motion to strike point, where the standard has now changed, right? And now we're at it's a no evidence summary judgment is how the language reads, right? And so at that point, and like here, we move for essentially a no evidence summary judgment and say you have no evidence of duty, and then it's their burden to come back with a scintilla of evidence to show that there was a duty. And so I think that would be the distinguishing factor of when it would be applied. And then, of course, obviously at trial, you could not move, just as in any case, you don't necessarily have to move for summary judgment. You could certainly wait, until trial or submission to have that discussion based on what evidence is presented at trial. And so, anyway, so turning back, to 33003, I think, that is where we would really focus the court's attention. But it really, and I know we kind of walked through it in our brief, but it's really every provision of the Proportionate Responsibility Act sort of contemplates a cause of action, right? I mean, if you look at 33001, it talks about the plaintiff's, percentage of responsibility, that's contributory negligence. And if you go to 33002, this chapter applies to any cause of action based in tort, right? So right then, you're talking about causes of action. The pleading standard, right? When you plead a claim, when the defendant pleads a claim, they have to plead it to meet the pleading standards of the rules of civil procedure. Well, Rule 45 and Rule 37 require that you plead a cause of action. So if your cause of action, and here the cause of action that they pleaded was a negligence, claim, then for a responsible third party, you would then have to show duty, right? That responsible third party, at least in negligence, would have to have a negligent duty and, and meet all of the requirements for a negligence cause of action to ultimately be submitted onto the charge. And then even moving, and I think one thing looking through the statute, there's a word that runs through it, right? Responsibility, that's not really defined anywhere. You've got percentage of responsibility, but responsibility isn't defined. And so, I mean, looking at, just looking at Black's Law Dictionary, right? What does responsibility mean, right? The quality, state, or condition of being duty-bound, answerable, or accountable. We're right there in that word is, I think, everything that we need to know, right? You have to have a duty. Your responsibility isn't just causing it, right? It's being accountable for it. It's having a duty.
Does the restatement of apportionment of liability shed any light on this issue?
I don't know the answer to that.
I want to be sure you have time to talk about the Occidental issue and,
Right.
and why shouldn't we distinguish Occidental because in this case the party was paid for the work that it was doing as an independent contractor.
Well, and I think that's where we would dispute the facts, that the party wasn't paid as an independent contractor. The party had a working ownership interest.
So they
in
weren't
the well.
paid, they just benefited from it as a working interest owner?
Well, they weren't, I mean, they shared in the cost, and then they got the profit in proportion to their interest, into their
So
ownership interest.
they weren't paid.
Well, I think that the record shows that they got like an operations fee, right? Or something for that extra, for what they did. Now, I don't think getting an operations fee creates an independent contractor relationship, right? I mean, that's two property owners, just, and let me just back up and say, there's no JOA or any contract in the record, right? So we're tenants in common, because that's what the common law provides, absent, a JOA, well, even with the JOA, but they're tenants in common, so those tenancy rules apply. And I think part of looking at duty is we have to look at the duty that they're trying to assert. They pleaded a negligence duty, right? So as a premises owner, I don't have a duty to not create a dangerous condition on my property, right? It's my property. I can create a dangerous condition. My only duty is when someone comes onto the property, and then it depends on who that person is and their status.
But what I'm trying to figure out is, were they also an independent contractor, and therefore did they owe a duty in that role, either in addition to or separate from the premises
Right,
duty?
and I don't think there's any evidence in the record of any kind of independent contractor relationship.
But if there were, then do you agree that they would have owed a negligence duty even though they had an ownership interest? So if you own 95% of the land and I have a 5% interest, but then you hire me to come in and dig the ditches and I fail to bury them safely after digging them,
Right.
do I have an ongoing negligence duty even after you and I sell the land?
I don't think so, because when you come onto the land, you're doing it as an owner, and you
Well, no,
have
I'm doing
the
it
right.
because you, the 95% owner, have contracted for me. We could have contracted with anybody to come dig the ditches, but we decided to contract with me to dig and you paid me extra to
Right.
come in and dig the ditches. Now, would Occidental apply, or would I have a duty ongoing?
I don't think there's any ongoing duty, because and it stems from your rights as a property owner. Even if they're paying you separately, that's between the two property owners, right? You still have a right, I mean, assuming your tenants in common, you have a right to go onto that property and dig the ditch, and you don't have a responsibility to
But do
do
you,
that in a
if you're
safe
if
manner.
you're a minority owner, do you have that right to go on and dig the ditch if the other owner says, no, I don't want you to do
Well,
that?
in the oil and gas context, you do. They cannot, a minority interest owner is a tenant in common. They can go out and they can drill. Now, if they only have a 1% interest, that is a very, very risky and probably a poor business decision, because if they don't find oil, they're responsible for all of the costs no matter what, but they can do it. The remedy between the two tenants in common is not, they can't evict you from the property.
What if they're a non-participating working interest owner?
Well, if they're not participating, are you saying would they have a duty in negligence or
If they
premises
couldn't
liability?
go out there and dig the ditch because of the way their ownership interest is structured?
Like if they're a royalty owner?
No,
right.
but there are types of working interest where
Right.
you can't do that.
Right, okay, so if they can't do that, I think, that would be different. Then we would have to look at what the contract says and make the determination of whether we're gonna have a duty.
Any other questions? Thank you, Ms. Levy. Mr. Hollenbeck, you have 5 minutes.
Is there evidence in the record that they were paid?
Yes, Your Honor.
Where would we
Mandamus
find that?
record is tab 7, Exhibit J. It's the testimony of Jose Monroe. He's the corporate representative of USG Properties. He testified in answer to several questions that, yes, Aruba was paid a fee as the contract operator. It's the same fee that Eagleridge, as the current contract operator, was being paid at the time of this accident. So there is absolutely evidence in the record that Aruba was paid separately a fee to be the Railroad Commission contract operator of record.
And could it have done that work without the permission of the other folks involved here?
Possibly. I think it would be, if it were not getting paid a fee to do it, just did it on its own as a minority working interest owner, it possibly could have. And again, the working interest owners all share in the cost, and so the others would probably say, well, you're going to pay all that cost yourself because we didn't agree for you to do that.
But in that case, Occidental would apply.
Occidental would apply. And our position is, but for Aruba being the contract operator of record, Occidental would apply. And we wouldn't be saying otherwise. But this case falls right in that area acknowledged by this court in Occidental, going back all the way to Stracos and the restatement of torts, talking about this same situation, that if you're the contractor, and again, I want to touch on something, very good question you asked me about duty. Aruba had a duty at the time it was doing the work. What Occidental just says is, okay, if you're solely the property owner and you sell the property, then you no longer have a duty going forward to something that happens afterwards. So Aruba had a duty at the time it was burying the pipe and not burying it properly, not putting anti-corrosion materials around it, and maybe not telling USG what it was doing. It's hotly contested by USG, who I don't represent, what it knew or should have known, and that's reflected in its briefing to this court. So I don't want to take a stand one way or the other about what USG knew or should have known, but Aruba had a duty at one time. And so we think that this is very similar to other cases the court has considered where there is a bar to liability at the time the lawsuit is being pursued against the responsible third party. That they have a protection either by statute of limitations, statute of repose, bankruptcy. In a criminal premises security case, you can't identify maybe the criminal assailant, and so you put an unknown John Doe on the charge as an RTP. We think this is no different, just because.
It kind of sounds like what you're saying is not so much that Aruba had a duty at one time, but that there was a standard of care that would govern the work Aruba did at one time. But there's no, if Aruba were the sole owner and there were no contract, Aruba has the right, there is no duty that prohibits Aruba from creating a dangerous condition on its property. It may not be meeting some standard of care,
Yeah.
but it has no duty to anybody. If you want to go out and dig a ditch on your property, you're not breaching a duty to anybody. You may be breaching a standard of care that could apply if a duty did exist.
Right. Well, I guess what I'm saying is Aruba owed a duty in this case because it was a contractor. And not solely in the
It owed a
capacity.
duty to the Leverns,
It
to the
owed-
plaintiffs in this case. That's the disconnect that when you're talking about the John Doe criminal assailant, it's
Sure.
because the criminal assailed the plaintiff.
Well, this court has held in Stracos and in Occidental that a contractor who creates a dangerous condition does owe a duty to somebody who comes on the property later and is injured. It always seems to come up in situations where somebody steps in a hole that wasn't covered up, like in the AEP versus Arredondo case this court considered last November. But yes, there is a duty, and Aruba owed a duty to the Leverns. All I'm saying is if you look at the statute, the words of Chapter 33, we don't even necessarily have to prove that a duty existed at the time of the injury, because a duty existed prior to that, when it was doing its work.
Its duty was to make the condition of the premises safe for a future invitee.
Yes, the same as the duty owed by Mr. Gehring in the Stracos case, the same as any of the cases where the court has looked at a contractor comes on the property, does work, creates or leaves a dangerous condition, and then leaves the property. That is a duty the court has acknowledged. There is already a duty that exists in those circumstances that is owed by contractors. We're not trying to create a duty. And one of the perhaps pernicious effects of saying that if a contractor owns any part of the land, any percent interest of the land, whether it's a minority working interest, whether it's a 1% fee simple interest, is that you could have clever contractors who come on the property and say, okay, I'm going to do this property. I'm going to build this, whatever, this improvement for you, but you've got to sell me 1% interest in the land, which I'm going to give back to you when I leave, and therefore immunize themselves from liability to third parties and plaintiffs down the road forever.
Any other questions? Thank you, Mr. Hollenbeck. Case is submitted, and the court will take another brief recess.
All rise.